Second, there are handouts. Don't forget to get them when you leave today. Also, you'll see on the one handout there's an evaluation in the back. That's just for people who didn't get that handout at the workshop. It's for your benefit. And the separate evaluation is the one for this event, because the key question in that feedback is, what events do you want to have in the future? Because we're getting ready to develop the program for next year. We do know there's some things we have to repeat, and so we do want to know what everybody would like, or if there's a topic we've missed, or if you want a repeat of something or whatever. Also, this is being taped today, and last year's tapes are in the library, and after the June session, all the tapes from this year will be put in the library. So they're available, but we never tape the workshop. So if you attended the workshop, that's very personal. We don't tape that session, but we do tape all the presentations from our speakers. I'm going to introduce, I'm going to say a little prayer, very short prayer. Oh, you're going to do it, okay. Yeah.
Thank you. I don't have any formal thing to do here right now, so don't worry. And I've already asked everybody for money at all the masses for the last 2 weekends. But what I do want to say is thank you, for Barbara and for the team, for Audrey and for the team. Barbara and Ronnie are somewhere else, and for Shannon for being here today and being with us again. I thank you for your interest in doing something proactive to benefit yourself or your children or your family. Please pray for me, because we're still trying to have that conversation with my mother and father. But I just wanted to say thank you. Can you stand here where I can see you? So I'm talking to them at the same time. You probably have no idea how much work has gone into this. And I know. And I'm only sorry that I was not able to be here for the last session. I can't be here for this one, because I thought it was at least a personal way of supporting Audrey, in this important work. She's been groundbreaking in helping us to refine a program that will be then going further out throughout Howard County and other places. And because the ultimate result is not just that there are papers that are put in a box that people know how to get to when someone dies, it's the fact that there's a sense of companionship and completion and even an assurance that when that time comes that we all dread, things will be in place as people want them to be in place, or people's wishes will be done to the extent that we can follow them. I can't think of something that is more priestly or more pastoral. And although she didn't go into the convent, she went out and committed marriage. Is Bert here too, by the way?
No, he's at a Boy Scout thing this weekend. I was in the convent. That's why he's laughing.
So I want to thank Bert too. So that's it. That's my bit. But thank you so much.
Thank you. I am going to start with this little prayer that a friend of mine shared on Facebook this week, and I was like, oh, how appropriate. And Father Jerry appreciated it too. So here we go, very short. Lord Jesus, prepare me for my own personal end times. May I fulfill your will in my life and be at peace with your perfect timing for my death and an entrance into eternal life with you. Amen. And I'm going to introduce Shannon, who has an elder law practice that is probably going to be expanding, but she was, if you came last year, you know what a wonderful speaker she was and how a wealth of information. So we're really excited to have her back.
This makes me very tall. Okay, can I slide it out of the way or push it in? Okay. Good afternoon. Thank you so much for having me back. I really enjoyed the opportunity to speak with many of you last year, and was fortunate enough to work with many of you after last year's presentation. So I was very excited and honored when I was asked to come back, and then to learn that I had an hour to talk to you instead of 10 minutes like last year. We had a panel. And so I know that Audrey has been working to bring this conversation project topic to your parish and bring a lot of interesting speakers and presenters to help you plan for end-of-life decisions. And that's what I do day in and day out for almost 12 years now, is talk about death and dying, and helping people express their wishes, put those in writing, and have conversations with their families. More important than anything that goes in those documents is the conversation that you can have with your family members. And I tell my clients all the time, if I drafted a 100-page advance directive for you, that still would not cover every medical scenario that might arise in the future. So it's more about the conversation when your children and your families are in the hospital room or at your bedside having to make decisions for you. More likely than reading the document that I've prepared for you, they're probably thinking about comments that you've made and conversations that you've had, observations that you might have had about a friend's passing or another family member's death that has helped to mold the way that you feel about death and dying. And I don't mean to talk about it so frankly in a way, I hope that doesn't offend anybody, but that's what it is. And my job is to help that process go as smoothly and as much like you would want it to go as possible. So I'm taking not a departure, but kind of expanding on everything leading up to those moments today. A large part of my practice, probably 70% of the hours we spend in my office, are on helping people plan for long-term care. So not just the moment of death or the days leading up to death, but possibly the months or even years leading up to that point. And this is something that people are very concerned about. It can be financially devastating. It can be emotionally devastating to families when you haven't planned for these events. And, you know, I won't scare you with statistics, but the numbers are pretty high that everybody is very likely to need some period of long-term care. So avoiding the topic or burying our head in the sand doesn't mean these things won't happen. It just means that you won't have the opportunity to make the decisions for yourself or to plan for them ahead of time. So those are some of the things I'd like to talk to you about today, those years, the planning years leading up to death. Let me see if I can... So I want to give you some ideas about ways that you can prepare for long-term care. And actually, let me already stop right there. Nothing that I tell you today is intended to be legal advice to any one of you individually. This is purely educational in nature.
I'm going to interrupt for one
Yeah.
second. I know a lot of people have trouble with hearing and the water's competing.
Oh, sure.
So I'm going to, but I have to go on the hearing.
Oh, okay. Oh, great. Thank you.
Sorry.
So just a little disclaimer, don't go and implement any of these strategies that I'm about to discuss with you on your own today without consulting with somebody who's familiar with your individual circumstances. But I'm going to give you some ideas about ways that you can prepare for long-term care, the types of documents that you need. I met with a client just this past week, who described this part of the process brilliantly. He said, this is the infrastructure. He said, so what you're saying is I need to get the infrastructure in place for my mom so that if we come to that moment where we really need to spring into action in terms of long-term care planning, we have this infrastructure of documents and powers that we can implement at the time that need arises. And I thought that was a perfect way to describe it. We'll talk about any specific language you might want to consider including in your estate planning documents, because really all of long-term care planning begins with estate planning. Any important changes that you would make to or would want to consider making to a spouse's documents. If one spouse required long-term care, the spouse that would be remaining at home, there are some tweaks and fine-tuning opportunities there. We'll talk about gifting and why that's such a bad thing in the world of Medicaid. Reasons why not to give away your assets. People get so concerned about long-term care, and they come in my office at the age of 55 and say, I think I just should give everything to my kids so that if I needed to apply for long-term care in the future, I don't have any money and we would be good to go. So let me give you a million reasons why you shouldn't do that. We'll talk generally about financial eligibility for Medicaid. I'm sort of using the terms long-term care planning and Medicaid planning interchangeably. They're not truly interchangeable. Medicaid is really an option available at the highest levels of care. And I work with many long-term care planning clients where we're not planning for that highest level. We're planning to try to keep them in these lower levels of care and consider other sorts of financing options that are available there. So we'll talk about all of that. How the rules are different, whether you're single or married. And then also some asset protection strategies. So hopefully some things to help you sleep better at night, knowing that you won't have to impoverish yourself or your family in order to get access to the care or benefits that you need. So as I alluded to a moment ago, just to kind of put this into context, so we're setting the stage here. We keep talking about long-term care planning, and I believe the bulletin last week and the topic of this presentation has to do with helping family members plan for what's to come if they have a diagnosis of dementia. And there are many things, often when you get a diagnosis of dementia, you might spring into action and take care of all of the medical things that come to mind, and getting on the right medications and regimens and caregivers and all of those things. But that should also be a point in time to pause and make sure that all of these legal housekeeping items are up to date as well. A diagnosis of dementia does not automatically mean somebody is not capable of signing documents, so that's very important to understand. I have clients with all degrees of dementia, all types of dementia: vascular dementia, Lewy body dementia, Alzheimer's dementia, frontal temporal lobe dementia, dementias you probably have never heard of. And I work with them in all stages of this disease and this illness. So we try our best to make sure we give that client every opportunity to demonstrate to me that they are capable of making their own decisions, so that I can capture that moment and memorialize it in a document that they're capable of understanding. And we give that many good faith tries. So if I visit them on one day and that turns out to not be a good day, we might try again the following week on a different day or a different time of day, trying to catch them in a moment of a period of lucidity when they're able to appreciate what I'm talking about in plain English and make these decisions for themselves. So just because somebody has been diagnosed with dementia, don't think that that means, oh, we've already missed the boat. We can't get these things in place. You probably have many months, if not years, of time when you can still make sure that these affairs are in order. As I mentioned before, this is about creating the infrastructure. A lot of the complicated planning that I do is not done more than 5 years beforehand. It's really done right at the time the need arises. So we'll talk about that. Some people have an adverse reaction just to hearing the word Medicaid. So I just want everybody to not write it off, okay? Just let me explain to you what it is and what it isn't, and why people who think that they've adequately self-insured or have long-term care insurance, I still end up helping those people qualify for long-term care benefits, depending on how quickly they're spending their finances. And so we'll talk about other ways to pay for long-term care, including private pay, long-term care insurance, Medicare, which is extremely limited in terms of long-term care benefits, and then lastly, Medicaid. So as I said, estate planning is really the foundation for long-term care planning. The single most important thing you can do to take a step toward long-term care planning is have your basic estate planning documents in place and up to date. And when I say basic documents, I'm referring to your last will and testament, a financial power of attorney, and an advance medical directive. So your last will and testament obviously describes what happens to your property upon your death, which is very important. It allows you to appoint an executor of your estate, which is important. Your financial power of attorney and your advance medical directive are what I call your lifetime documents. So these are in effect while you are alive, but for some reason unable to make medical or financial decisions for yourself. There's additional language, and I think this is an important distinction. You know, my title as an elder law attorney and not just an estate planning attorney is the distinction that the content of these documents, when you work with an elder law attorney, is really geared toward keeping those long-term care planning options open. And that is, I think, a very important difference between somebody who does wills on the side in addition to DUIs and divorces and whatever else, and they can also do your will, compared to somebody who dedicates their practice to elder law, and they're familiar with both the pre-planning and the crisis planning, so to speak. In my opinion, of these three documents, everybody puts a lot of emphasis on the will, and the will is very important, and I think you've had a lot of speakers come and talk to you about the importance of an advanced medical directive, which is also very important. In my opinion, the single most expensive document for you not to have is your financial power of attorney. Let me tell you why. If you die without a will, there are laws in the state of Maryland that say this is who gets your stuff. It might not be in exactly the same percentages or shares that you would have chosen, but it's probably pretty close in most cases, okay? In some share, it will go to your spouse and your children. If you don't have a spouse or children, it will go to kind of your next closest circles of family members, okay? So it wouldn't be the end of the world if you died without a will. If you get sick or incapacitated and you don't have an advance directive, there's a law in the state of Maryland called the Surrogate Decision Maker Statute, which I spoke a little bit about last year, that allows certain people in order of priority to step up and make medical decisions on your behalf, even in the absence of an advance directive or medical power of attorney. And so the law lists these people in order of priority, I believe beginning with guardian of person, if somebody has been appointed as your guardian, and then it goes to parent of a minor child, and then it goes to spouse, and then it goes to adult children. So again, it kind of follows the order of people you would probably naturally choose as your healthcare agent. If you become incapacitated and you do not have a financial power of attorney in place, there is no default law that says, oh, these people can just have access to your bank account to pay your bills, or these people can cash out your IRA if we need that to pay for long-term care, or surrender your life insurance so that we can prepay your funeral arrangements. Nobody has authority to do that. Forget joint account titling. I'm not talking about a jointly titled checking account. Maybe your spouse, maybe a child can write some checks for you. But retirement accounts and life insurance policies cannot be touched. Those are individually owned assets. Your home, even if your home is jointly titled, you don't have authority to sign off on a deed or a mortgage on somebody else's behalf. You can't change the title to the house unless you have a power of attorney. So when I sit down for long-term care planning and I ask those clients to bring me their documents or their parents' documents during that meeting, within the first 5 minutes I've read the entire power of attorney, because that will dictate what I can and can't do on behalf of that incompetent client that I'm planning for. It's all right there in the power of attorney. So let me talk a little bit more about what sort of things I'm looking for in that financial power of attorney. As I said before, everybody puts a lot of emphasis on the will, and especially who their executor will be. Who, in Maryland, that person is called a personal representative. Everybody agonizes over their personal representative nomination. That person has very little discretion, very little decision-making authority over your property. They are, what I tell my clients, your foot soldier that is executing the marching orders of your will. And they have to report to the court, and they have to distribute your property according to the terms of your will. They don't get to decide who gets what and in what shares. They just have to get the job done. On the other hand, the agent that you name in your power of attorney has all of the discretion in the world. We're not telling this person what to do. We're simply giving them the power to do whatever they think is in their best, in your best interest rather, at the time. So it is critically important that you choose somebody that you trust implicitly to make responsible decisions with your finances and for your benefit. In Maryland, 8 years ago now, almost 8 years ago, we passed a brand new power of attorney law that did not exist in any form before 2010. So prior to 2010, every attorney would use their own power of attorney document. So mine would look different from the next person and different from the next person. And the problem with that there was no uniformity among the documents. So banks would take ages to review these documents and would often come back and say, I'm sorry, but we only accept our own power of attorney form. So could you have your mom or dad sign this new one? The problem is that you might not be able to sign a new one at the time somebody is actually presenting the power of attorney on your behalf. That was one of many problems that was happening. So finally, the banks and lawyers agreed on this new form, somewhat of a standardized form, but I use that term loosely because you're not required to use it. It also means that any document, a power of attorney that you have before 2010 is not automatically invalid. Okay, it's still good as long as it was good before 2010. It's still valid today. But there are many benefits to using one of these new standardized forms. And the most important of those benefits is that third parties like banks in Maryland cannot require you to sign any other power of attorney as long as you use one of these two statutory forms. Okay, so we have a personal financial power of attorney form, which is really just a fancy name for a general power of attorney. And then we have a limited power of attorney form. Both of them are written into the law. I typically use the personal financial or general power of attorney, so it covers the full gamut of powers that you would want your agent to have: banking, real property, taxes, stocks and bonds, retirement accounts, all of the standard things you might think of. And then at the bottom of that form, there's a special instructions section. And just sort of an interesting aside, when the statute was drafted, I don't know if it was 5 lines or 7 lines or 10 lines that the legislature actually passed in the final version of this bill that became the law for special instructions. Leave it to lawyers to make a mountain out of a molehill over 5 versus 10 lines, whatever it is, and immediately there was a division among estate planning attorneys whether that meant, well, does that mean we can only provide 5 lines of special instructions? And so if so, then do I have to shrink the font down really small? And I'm not kidding that I've seen powers of attorney with 6-point font to try to fit all of the special instructions on 7 lines or whatever it is. And then some people, because they were worried that if they modified the form too much, if they added too many lines, that then you might not have the statutory form. And so they were trying to preserve the protection that you had under this new law. So anyway, the point of this comment is some powers of attorney, especially that were drafted right after that law passed, you might, if you have a newer power of attorney, you might have the statutory form, and you might look at your special instruction section and it's blank, and then you might have a supplemental power of attorney. So that was one approach, is that when attorneys that got real nervous about those 5 or 7 lines, they said, we're just going to put all the extra powers in a supplemental power of attorney so that you have 2 separate documents. And then other people said, there's no way that we were intended to be limited to 7 lines, and I'm going to put all the powers in there. So the point that I want to make is, even though I've told you that this is a form, if you wanted to go look it up online, you could. I would strongly discourage you from signing it and thinking you're good to go. Because there are many powers, specifically the long-term care planning powers, that are not part of the standard language that would go in the special instructions section. So it's good that we have a form, but it's not perfect, and it still needs to be tailored to meet all of these needs. Choosing your agent on a power of attorney. As I mentioned before, this is probably the most important appointment that you will make in any of your estate planning documents. You want to be sure that you choose this, you trust this person's judgment, because they will be making all of these decisions on your behalf. Whether you name primary and alternate agents, first child number 1, then child number 2, or maybe spouse, and then child number 1, and then child number 2, the preferred method would be primary and at least 1 alternate, if not 2 or 3, or however many trusted alternates you might have. Some people insist on naming co-agents. They want their children to act together, or they don't want to hurt somebody's feelings by being left off of the power of attorney. And in the back of my mind, I'm thinking, I would love to be the child that is left off of the power of attorney, because it's an enormous job. It can become a full-time job. But people really agonize over that part of the decision. So if you really want co-agents, then you need to consider that that means true co-agents requires 2 signatures on everything, 2 signatures on a check, 2 signatures on an admission agreement to a retirement community, 2 signatures on a deed, 2 signatures on everything that needs to be done. That's what co-agents mean. And then if those 2 people don't agree, now you have a problem. So the only way that one of those co-agents would be able to supersede the other agent would be to go to court and get an order appointing them as your guardian of property. And now they jump to the top of the decision maker list. And that's exactly what you're trying to avoid by having a power of attorney. So really give a lot of thought to whether you want them to be co-agents. Another option is joint and several agents. So that's, again, where you have multiple people acting at the same time, but joint and several means that they can act together or independently, which sounds a little bit better, because then you might be avoiding the stalemate issue, but then you might be creating an issue where your child here in Maryland goes to this Bank of America and your child in Virginia goes to a different Bank of America, and now you've got a problem there where the left hand might not know what the right hand is doing. So none of these are absolutely right or absolutely wrong. They're just things to consider when you're executing your financial power of attorney. Whether it becomes effective immediately when you sign it, or it springs into effect upon some future event, which is normally incapacity, that's another decision you have to make under the power of attorney. So most people think of a power of attorney as only being used in the event of incapacity or disability. And so that means we have language in the document that say, 2 doctors must certify that I'm no longer able to make responsible decisions regarding my finances. And that might sound good, because then you can sleep at night knowing that nobody has immediate access to your finances. But what you've really done is created a lot of extra hurdles for that person to jump over in order to act on your behalf. And I urge you to think about how that looks when they implement that. So even if they drag you to 2 doctors and get the doctors to examine you and they sign certificates that say you don't know how to make decisions about your finances, now your son or daughter is going to take your power of attorney and the 2 physician certificates to the bank. Who are they going to talk to at the bank? The teller? Maybe they sit down at a desk with a manager, and now somehow that's going to make it up the food chain to the legal department. Their lawyers are going to be reading the language in the certificates to make sure does it exactly mirror the triggering language in your power of attorney, because they don't want liability for letting somebody have access if they're not really supposed. I could go on and on. So you're creating this problem that you didn't intend to create. And if your concern is about your agent having immediate access to your finances, I would encourage you to reconsider naming that agent to have control of your finances when you're incapacitated. So it's better in practice to make your power of attorney effective immediately and not necessarily contingent on your disability or incapacity. With me so far? Okay. The really important powers that I mentioned that are not part of the basic statutory language, especially gifting, beneficiary designations, and trusts. So, and including disclaimers as well, which are sometimes appropriate, but not as much anymore because the tax laws have changed considerably. Gifting, okay, we're going to talk a lot about gifting today. Gifting is probably the single most used strategy in long-term care planning. And I don't necessarily mean gifting to other people. I might mean transferring assets between spouses, which you might not think of as a gift because you think of it as one big pot, but it's considered a gift. If I wanted to take your name off of the house and transfer the house to your spouse to protect it from a lien, for example, that's a gift. I'm giving away your 1/2 interest in the house to your spouse, and I'm not going to pay you for it. So legally, that's considered a gift. If you go home and read your power of attorney and you don't see anything about gifting, but you might see a provision in there that says, after they've listed all of these specific powers, there's a catch-all power at the end of the document that says, oh, and any other thing that I forgot to specifically enumerate in this power of attorney, anything else that I could do, my agent has the power to do for me. Well, Maryland law has said that's not good enough. That does not include gifting unless you specifically, expressly authorize gifting in your power of attorney. And I didn't fully appreciate why gifting was so important early in my practice when I just was doing estate planning and not long-term care planning. But as I mentioned, it's probably the most widely used power for asset protection purposes in long-term care planning. So you want to make sure, or at least consider, whether you would want your agent to have gifting powers Changes to beneficiary designations. You might be thinking, why would anybody need to change my beneficiary designations? Well, I'll show you more in a minute, but in a situation where I'm trying to get one spouse eligible for Medicaid, for example, I might be transferring all of the assets to the community spouse or the spouse at home. Well, I still have to plan for the possibility that maybe my spouse at home dies before the spouse in the nursing home that I thought would pass first. And if that happens, that spouse at home, all of their assets probably say everything goes back to my wife or my husband in the nursing home. That's not what we would want to happen after I've moved everything over into their name. So we would update their beneficiaries to bypass the surviving spouse in the nursing home and have that money go directly to their children as a form of asset protection. So that would be a reason why you might want your agent to be able to make changes to your beneficiary designations. And trusts, which would be an entirely separate seminar altogether, but there are certain types of trusts that can be used to protect your home and protect assets in the event of disability or incapacity. So if you don't have that type of trust in place, which I'm not saying that you should, but you still want to keep that possibility on the table for your agent to be able to create a trust for your benefit and on your behalf. If I said, hey, it would be a good idea if we had a trust for your mom or dad, that's the power I would need them to have to be able to do that. So now that we've talked about why gifting is so important, let me tell you why not to make gifts. So there's a lot of confusion around gifting, understandably, because there are conflicting rules in the world of taxes that are conflicting with the rules in the world of Medicaid. Many people come in and they say, oh my gosh, I thought I could give away 10 or 12, they usually say the wrong number, this year it's $15,000 per person per year without any problem. You can, if you have so many millions of dollars that you're trying to spend your estate down to stay below the $11 million federal estate tax exemption or the $4 million Maryland exemption, then you're doing exactly the right type of gifting, and you don't have to file a gift tax return. But that's not most people in my office. Most people in my office are not multimillionaires. They have a little bit of money, and they've just been misguided at some point where they thought they could give away that large of a gift for Medicaid purposes, and that it didn't matter. But that's not true. So has everybody heard of the look back? Have you heard that word mentioned by people? So what the look back period means is from whatever date you apply for Medicaid, so that means you're in a nursing home, we've demonstrated that you're not able to pay for your care in the nursing home, so we're applying for Medicaid. Medicaid, or the state, will look back for 5 years from the date of your application. If we're asking for June 1st, 2018 eligibility, they will look back to June 1st, 2013, and they will scrutinize every single transaction on every single account, generally over $1,000, but that's an unwritten rule. Okay, so they can scrutinize anything they want to, but typically they're skimming through looking for things over $1,000. And the presumption is against you that any transaction over $1,000 that you can't explain must have been a gift and must have been made for the purpose of establishing Medicaid eligibility, because you knew you would be here. That's the reasoning. You knew you would need to apply for Medicaid. So we will penalize you for every gift that you've made over the last 5 years. And what they do is they add up those gifts over that 5-year look back, and then they use this penalty divisor, which is currently 8684. You don't get too worried about these details. These are the things that I'm just explaining for your general knowledge. And that's the average cost of care in the state of Maryland, according to the Department of Social Services. And so if you gave away $86,840 incrementally over the last 5 years, and now you apply for Medicaid, you would have a 10-month penalty. Right? Because they just applied the divisor and they say, well, you're eligible for Medicaid because you're below the limit, you're in the nursing home, you meet all the requirements, but we're going to penalize you because you made these gifts. So we're not going to pay for the nursing home room and board, which is the exact reason you're applying for Medicaid, because you made these gifts. You have to wait out that penalty period. So why not do that? Why not just give away everything right now, so that you don't ever even come close to that look-back period? Do it now while you're healthy and you don't have any reason to anticipate the need for nursing home care. Well, think about what that really looks like, okay? To give away all of your assets to a child, for example, because you're afraid that this could happen down the road. You have to give up control over those assets. Giving them away doesn't mean adding your child's name to a bank account as a joint owner. That's not a completed gift. Giving them away means giving them away. And how do you give away your retirement? Are you going to cash that out? You can't transfer ownership of a retirement account. You could transfer ownership of a life insurance policy, but you'd have to give up control over your finances. And usually my clients that are young enough and healthy enough to even be thinking about this type of option are the same people that I would say, think about, are you going to call your child when you need to replace your hot water heater, or you need a new car, or maybe your income is short that month and you need money for groceries? They hold the purse strings. In order for that to be a completed gift to accomplish this purpose that you're so worried about, you have to give up control over that money. I personally don't believe that that's a practical way to live, especially that far out of the need, the possible need for nursing home care or applying for Medicaid. So all of those things we talked about in your power of attorney are the reasons why you shouldn't have to do this. If you have the gifting powers and you have the beneficiary designation powers and trust powers in your documents, then you don't need to worry about trying to implement the asset protection strategy today that you may or may not need 5 years from now. That's what your power of attorney will do at the time the need arises. And another reason not to give all your stuff away is that once you've given it away and you do make a completed gift, now that money legally belongs to that child. And so the bottom point there is that that exposes your assets to that child's creditors. And I don't mean creditors like they're in debt. I mean like if they're in a car accident or if they get divorced or anybody sues them for any reason whatsoever, your money becomes exposed to their creditors. So if you've talked to an attorney about any of these things, you might be thinking in the back of your mind right now, well then why not just put them in a trust? Same problems for the most part, except that a trust is that much more complicated to undo. If we needed to undo it, if we made a gift to a trust and then we didn't get past that 5-year look back, we'd have to undo that because we'd have an unintended penalty. So many, many reasons, just these are a few, not to give away all of your money more than 5 years before you actually might need to consider Medicaid. As I alluded to a moment ago, the view on gifting is that any money you've given away over the last 5 years was done for the purpose of becoming eligible for Medicaid, and therefore you are presumed guilty until you can prove yourself innocent. The burden is on you to provide evidence that that had nothing to do with Medicaid. Fortunately, in 2013, that rule used to apply to any gift. I mean Christmas, I mean weddings, I mean birthdays, I mean any gift that you would have made to a family member could be penalized against you for Medicaid purposes. In 2013, the state finally recognized a list of common gifts that have nothing to do with qualifying for Medicaid and now will not be penalized as long as we can provide some amount of evidence to show that this was the purpose of that gift. Let me give you some examples. The first one there, traumatic onset of a disability. So that would mean, let's use a stroke as an example. That could be a traumatic onset of disability. Today you could be fine, tomorrow you have a stroke and you are never coming out of the nursing home and now we consider applying for Medicaid. Nothing that you did before the stroke could have been done for the purpose of establishing Medicaid eligibility because you didn't know you would have a stroke. You didn't know that you would be in the nursing home and looking at Medicaid a month later. So any gifts that are made prior to the traumatic onset of a disability, as long as we can show this was traumatic, there was no evidence that we were leading up to a stroke, there was no history of strokes, and we've used this argument successfully with a heart attack. I've had clients that have had devastating injuries from car accidents that are never able to return home. Those are all traumatic disability events, so anything that happens before that time would not be penalized. Let's see some others that I've had. Natural disaster affecting the applicant or the family member. I had a client whose son's basement flooded and his insurance only covered the repairs to the exterior or maybe even the walls, but not the contents of the basement. And so his parents had given him a check for $10,000 to help him replace the contents of the basement. That was an example of a gift that had nothing to do with Medicaid, but I could prove it was a natural disaster affecting a family member. Let's see. Traditional gifts up to $200 or more if there is a consistent pattern. So charitable gifts that you make consistently every month or every year, gifts to family members. So let's use the religious milestones as an example. Let's say for every religious milestone you give a family member $500 or even $1,000. As long as there's a consistent pattern of gifting at a higher amount, then we can demonstrate those were not done for Medicaid eligibility purposes. The last one there is also interesting and is one that we have had the opportunity to get a gift or something that was about to be penalized as a gift excluded from penalty. I see a lot of clients who are opting to move their parents into their home for whatever reason. Other forms of care might be or too expensive. And so the parent sells their home and then they use some of that money to build an addition or an in-law suite or whatever in their children's homes. So that type of investment in a child's home is not considered a gift, no matter what the amount of money that is invested, as long as the improvements allowed the Medicaid applicant to reside in the home for any period of time. So if you moved in on day one and you had a fall and you were never able to come back there, it doesn't matter. The entire $100,000 that you invested to build that suite at your child's home would not be treated as a gift. So these are just important to be aware of. These are not things that I consider to be strategies. These are solutions to problems that come to the table, okay? So I don't advise people, okay, let's sit down and create a new pattern of gifting for you. Once we know that this is kind of coming down the pike, these are ways that I can clean up the problems that you bring into my office that you really had no idea were about to create a Medicaid penalty. We can say, oh, good, we fit neatly into one of these categories here. These are things that are more like strategies. These are things that I can use that are by definition gifts, but under the Medicaid rules are not penalized. These gifts are not subject to penalty. I've mentioned a couple times transferring the house to your spouse, and this is something that's routinely done in long-term care planning to protect the house from a lien. And so even though that's legally considered a gift, it's not penalized. Transfers of assets to blind or disabled children or into a trust for the benefit of blind or disabled children is not considered, is not subject to penalty. This last one is kind of the opposite of what I just described, where the parent sells their house and moves in with the child. Sometimes I have adult children who move in with their aging parents in order to enable the aging parent to remain at home. This one can be difficult to prove. But we've done it successfully in several cases where the adult child has to move in and we have to be able to demonstrate or document that that parent required a nursing home level of care, not assisted living, not some help with their medications, but a nursing home level of care, and that but for that child's presence in the home for 2 consecutive years, that parent would have otherwise been in a nursing home. So we have to get doctors to write letters that say, yeah, 2 years ago, they were already at this very high level of care, and thank God for this child that moved in and helped them stay at home. These are the types of things that the parent needed help with, activities of daily living, eating, bathing, dressing, toileting, all of these things. And we document that, and we have to get documents from the child to prove that they lived there, so driver's license or other bills that the child might receive at the parent's address. But if we're able to prove that, Medicaid will allow us, if we say, yes, we met the criteria, we can transfer the parent's home to that child free of penalty. That's an enormous opportunity. That's a huge asset protection opportunity right there. So that's, again, not really the thing you can plan for, but just letting you know that these things are out there so that not all is lost. So when we keep talking about Medicaid and eligibility, what does that really mean? For an individual applicant, somebody who is not married, they have to spend down, that's the dreaded word, spend down, their countable resources to below $2,500. And the best way to describe or define, rather, countable resources is to tell you what's not countable, which resources or assets are excluded. The home is excluded. So you can become eligible for Medicaid and own a principal residence. Now, that's not the end of the planning that happens with the house. That's just phase 1. So when you own a home and you become eligible for Medicaid, what's really happening there is Medicaid is fronting you the money. They are advancing the money on your behalf because you can't pay a nursing home with your house. So Medicaid says, all right, you spent all your other money, so we'll pay the nursing home while you're alive, but we will file a lien against your house so that when you die and the house is sold, we will recover the money that we've paid out on your behalf during your lifetime. So that's why I say at the initial eligibility determination, we can get by owning a house, but we usually want to do some other planning, whether it's a gift of the house, like we've talked about, or selling the house and doing something with the cash to try to protect some of the proceeds. Those are the other options. So we go beyond just the initial excludability of the house. Your car is excluded. Prepaid funeral arrangements are excluded. So if you've made prepaid arrangements of any amount for you and your spouse, those are all excluded. Cemetery plots are excluded. All related cemetery expenses are excluded. Opening and closing of the grave, the vault, the headstone, the engraving, all of that. Any prepayment of your expenses, funeral expenses, are excluded. Life insurance with no cash value, federal employees, FEGLI policies, excluded because there's no cash value associated with those. It's just a death benefit that's payable to your family. And any other term policies or non-universal life or non-whole life policies are excluded because there's no cash value there. Everything else is countable. All of your cash of either spouse, we're going to go to spouses in a minute, any account, bank accounts, checking accounts, CDs, stocks, bonds, retirement accounts, 401ks, 403bs, additional properties other than your principal residence, those cause a problem. Land, if you own a lot, an unimproved lot out in West Virginia where you've been hunting for 20 years, that's a problem, that counts. So everything else counts. And you might hear people, this is another point of misinformation, retirement accounts count in Maryland. Retirement accounts of the spouse that's not applying for Medicaid count. All right, that rule is different state to state. All of these Medicaid rules are different state to state because Medicaid is a jointly funded federal and state program. So the federal government has their general parameters, and then each state implements those dollars in different ways, and so you have a second layer of all of the state rules. And in Maryland, all of those accounts count, regardless of how they are titled, in either spouse's name. Adding your children to your account does nothing to protect the money in that account. So let's talk about marital limits. So for the individual, all the way down to $2,500, the limits for a married applicant are very different, as you see. So we have to first identify what we call a snapshot date. That's not actually what we call it. There's a more technical term than that, but some people call it a snapshot date. So we have to go back and identify the first point in time that this spouse went into a nursing home for more than 30 days. And that's the date that Medicaid uses to determine whatever you had on that date. The community spouse, the one that's not going into the nursing home, is allowed to keep half of whatever you had on that first date up to a minimum, or within rather, a minimum and maximum amount. And the current minimum is $24,720 and the max is $119. So this is easier to see in an example. So let's say on the snapshot date, as a couple, all in retirement accounts, everything you own, you had $200,000 in countable resources. Well, half of that is $100. And that falls very neatly within the minimum and maximum of the 24 up to $123,000. So we would have to spend you down to $100,000 in order for the nursing home spouse to become eligible for Medicaid. That spend down, that's my job. That's what people hire me to do, is help them figure out, how do I spend $100,000 in some way that doesn't make me impoverished, in some way that protects me, the spouse at home, because I'm not going into the nursing home. I don't need Medicaid. I still have to pay my taxes and my bills and buy groceries and be able to support myself at home. So that's what this resource allowance is designed to do. That's why the Medicaid rules are so different. The married rules are so different than the rules for an individual, because in a sort of cynical way of looking at it, the state is thinking, well, once we're paying for your spouse, we sure don't want you standing in line asking for help too. So we want to be able to protect your money, or allow you to protect a certain amount of money to support yourself so that you don't become impoverished. All of these rules exist under a chapter of the manual called the Spousal Impoverishment Protections to protect you against becoming impoverished. So you'll see there, the other example would be if you had $300,000 on the snapshot date, and half of that is obviously $150, well, that exceeds the max. So then we have to spend you down from 300 to 123. Really, I would always build in a little bit of wiggle room, so we'd probably go down to 120,000. And my job is to figure out, well, how do we spend $180,000 as quickly as possible? So those are the asset limits. For a single applicant, a gift in return is a very complicated strategy. I'm not going to go into great detail about this, but this is one way, one strategy that again ties back to the importance of the financial power of attorney and the gifting power in that document, where we use this gift in return, knowing those penalty rules that we talked about earlier. I can make a gift of any amount of money, and I can easily calculate what the penalty would be on that gift because I just divide it by 8684. And then knowing that the rules allow me to return part of that gift, which therefore requires the caseworker to reduce the penalty. So if you had originally gifted the $86,000 and you had a 10-month penalty and your child returned 43,000 of it, well then your penalty should be reduced, right? Because you really only gifted 43 now, you didn't gift 86. So this sort of back and forth, which is where people start to really get saturated with too much information, but this is called gift in return, and what it allows me to do is protect about half of the cash that's left over. We have no way else to spend it or protect it. Gift in return is one way that we can protect money for an individual applicant, a non-married applicant. Some other options for an individual applicant, more so than for a married applicant, would be using a special needs trust. So a special needs trust, by definition, means that you have to meet the definition, the Social Security definition of disability. Being old doesn't automatically equal being disabled. Sometimes it does, sometimes it doesn't. So it's not that there's an age threshold where everybody qualifies to put money into a special needs trust. We still have to prove that you meet the definition of disability. And if you do, then we could use a special needs trust as a way to transfer money out of the applicant's name and put it in this trust for their benefit. Now, why would I do that? I would consider that in cases where I have a particularly young applicant. So if I have like an early onset dementia case, maybe somebody in their early to mid 70s is young in my world. So that would be on the young end of the spectrum for people that I'm doing this type of planning for. I could consider using a trust. And I could transfer their money into the trust. There's no penalty for making that gift to the trust because I can prove that they are disabled by definition. The downside to the trust is that it has payback requirements. So any money that's left in that trust when the beneficiary dies must go back to repay the state first for any benefits that they have paid out on behalf of that applicant. So that goes to why I would not take the money of a 97-year-old client and put it in a special needs trust, because it would be very difficult for me to say we can definitely spend all this money down during their lifetime. It would basically be signing a check over to the state. But somebody who's in their 60s and I have $50,000 that I need to put into the trust, I could very easily pay for supplemental services that are not covered by Medicaid, additional therapies, computers, equipment, whatever they might need that's other than room and board. That's what the trust can be used to pay for. So again, it's not a one-size-fits-all plan, but just options that we have available, and that would fall under the trust power in the power of attorney. That's a good example of you would never create a special needs trust for yourself ahead of time. You would have no idea whether or not you would need one. That's the type of thing that you could empower your agent to do under a financial power of attorney. A married applicant. This is probably the most commonly used asset protection strategy in the world of Medicaid planning. So let's use that example that I had where we had $300,000 and I wanted to spend you down to $120,000. So we have to spend $180,000 as quickly as possible. So under the Medicaid rules, that $180,000 that we're talking about, that's an asset. There's a different section of rules about income. So under financial eligibility, to become eligible for Medicaid, you have to pass the income test and the asset test. The income test says that only the income of the applicant spouse, not the community spouse, only the nursing home spouse's income must be below the private pay cost of care in the nursing home. Well, that's true for almost everybody. Unless you have over $10,000 a month in retirement income, almost everybody passes the income test, okay? And only the nursing home spouse's income counts. That becomes important in this strategy. And then the assets, as I said, the assets of either spouse count. So all of the assets count, but only the nursing home spouse's income counts. So what the rules allow me to do, as we've talked about already, we know that I can transfer assets between spouses without penalty, okay? Even though legally it's a gift, it's not a penalized gift in the world of Medicaid. So I can transfer that $180,000 to my community spouse, no penalty there. Now the community spouse can use that $180,000 to purchase this Medicaid compliant annuity. All we've done under the rules is convert that $180,000 from an asset to income under the community spouse's name, which now does not count toward the nursing home spouse's eligibility. Now, why would I do this? Why do I not lose sleep at night using that sort of creative strategy? Well, I already told you why, because in the cases where we use these annuities, I have a spouse at home that is entirely dependent on that $180,000, maybe not to pay their daily bills, but for their ability to retire, for their ability to pay off their car, for their ability to keep their home, whatever that might be. So that's why we would take that big chunk of money and use it to purchase the annuity. So what's the catch? Why wouldn't everybody do that? Well, the catch is at the bottom there, just like with the trust, that when you use these Medicaid compliant annuities, you have to name the state of Maryland as the primary death beneficiary. So if the community spouse dies before they've received all of that money back from the annuity, the state gets first dibs over the remaining payments. Not the money that they've already gotten back, but whatever payments are left under that annuity contract. Now, how in the world would I minimize the risk that you die during the term of the annuity? Because I don't know when you will die, and you don't know when you'll die. So the way we use that, or the way that we do that, is to use the shortest term annuity available. If I say, well, let's go with a 10-year term annuity, there's a much greater chance that all of us will die over the next 10 years than over the next 2 years. So if we use this 2-year term annuity, it's just a matter of restructuring this money within the Medicaid rules. So now it's no longer an asset, it's community spouse income. And if any of you are familiar with insurance products, the type of annuity is called a SPIA, S-P-I-A. That stands for a single premium immediate annuity. And single premium means you only put money into it one time. And then immediate means that you get your first payment back in the same month that you purchase the annuity. This is not a deferred annuity. It's not a variable annuity. This is not the type of annuity that your banker sells you to make a commission. This is an annuity that is strictly used to preserve assets. You're not going to make a lot of money on it. You're not going to get a lot of interest on it. I don't know how you get any interest on it, honestly, because it's just coming right back out over 2 years. But it's a SPIA. And then, as I said, because it's considered income, that community spouse can reaccumulate that income. So even though on that eligibility date we might have to bring you all the way down here to $120,000, now you become separate financial entities. And now the spouse that's on Medicaid is one entity and the community spouse is separate. And now they can reaccumulate that annuity income that comes back in to support themselves. They can reinvest it and do whatever they had intended to do with it in the first place. Was there a question? Okay. We're almost done. I know this is about the limit of what people can retain or kind of follow along, but what's important here, you know, this would be like you have invited an IRS agent to come and talk to you about the Internal Revenue Code. You don't have to remember the code. You just have to know that if you have a question, that there are people that you can call that can navigate you through this process, okay? You're not flying blind here. The more that you fly blind, the more financial harm you're probably doing to yourself and your spouse than if you talk to somebody sooner rather than later. So as I said, the goal with the annuity concept, which again is often considered a gift. So for me to be able to implement that type of strategy, I still need that spouse to have gifting authority so we can move money between the two spouses to accomplish the annuity. The 2-year term annuity is the shortest term available in the insurance industry that I'm aware of. So if you know of a shorter one, I'd be happy to know about it. That's the only reason you would ever use a 2-year term annuity. Like I said, that's not done for investment purposes. It's just for this Medicaid asset protection strategy. Why it works, I just went through most of those points. The point at the very bottom there is to be sure that the money that's coming back in from the annuity, and by be sure, I mean I will be sure that you do this, is name beneficiaries, payable on death beneficiaries on whichever account is receiving those annuity payments. Because again, If my healthy spouse dies before my nursing home spouse, I don't want all of these annuity payments that we just worked so hard to protect to now be paid right back over to the spouse in the nursing home. So if we name the children as payable on death beneficiaries, then that money will go directly to those children outside of probate and outside of the will. I told you we were about there. So all of that together, you know, the most important thing that you can do in terms of pre-planning for all of that crazy stuff I just talked about is to get your documents up to date. Medical, financial, and your will. All three are important. I don't want to minimize the importance of any one of them, but that financial power of attorney is critically important to keep these options on the table for your family and your loved ones if you find yourself in this unfortunate situation, which everybody wants to avoid. And even if what we're doing has nothing to do with Medicaid, even keeping you at home, sometimes the strategies that I might develop for you or your family are contingent on the powers in your power of attorney. Don't download the form and fill it out. You've done yourself a disservice if you do that. You've probably revoked a nice power of attorney that you had from years ago that an attorney had drafted for you if you fill out the form online. So don't do that. You can read it to be aware of it and know what it is and know what it says, but strongly encourage you to consult with an elder law attorney. And let me just make a quick point about that. When I might have said this last year, so if you've heard this joke, just stop me. The phone book of all of the lawyers in the state of Maryland is about that thick. It looks like a regular yellow pages. Just tiny print of every single lawyer and their phone number in the state of Maryland. The national phone book of elder law attorneys is that thick. So the fraction of people that dedicate their practice to this type of law is very small. Those are the people you want to seek out. Okay? Those are the people that are familiar with these issues. They don't just do estate planning as a side project, but they are focused on how those documents will affect you and your family down the road. So if you want to do this type of planning, that's where you want to look, is for those elder law attorneys. I believe that's it. Don't give away all your money. You don't need to do that. I've just given you many, many reasons why you don't need to hurry up and give everything away. Now you are aware. You can't say I didn't tell you so. Now you're aware of the consequences of gifting. You don't get to give away $15,000 per person per year for Medicaid. Any amount of gifting can create a problem. And the annuity that I talked about, the gift in return, which I barely talked about because that will really make you fall asleep, all of those things are done right at the time we need to apply for benefits, okay? So you don't have to do these things years and years and years ahead of time. And as I just mentioned, people that do this type of work on a regular basis can help you protect your assets. So the sooner you call somebody, the more good you're going to be able to do for yourself. That's all I have. So I'll take questions. Yes. Thank you. Thank you. I think Audrey has a microphone and she'll pass around for questions.
My main interest, and I hope I didn't miss it, is gifts to grandchildren for education. What kind of background do you have to make that an exemption?
So it is on the materials, gifts to grandchildren for education. A lot of people use 529 plans as a way to do that. Unfortunately, those 529 plans are considered countable assets. So if you needed to apply for Medicaid and you have a 529 for your grandchildren, it does have to be spent as part of the pot of money. However, payments directly to an institution for the benefit of an immediate family member are not penalized as gifts. Okay? Now, I'm not saying that's what you should do, because there are tax advantages to the 529. I'm talking strictly about Medicaid consequences, but payments directly to a college or a private school, anything like that, payments directly to an institution would not be subject to penalty. So that's something to consider, whether that's something that you could do or not. You know, your circumstances will dictate whether that plan works for you. Right, don't do that. So anytime you can avoid flowing money through your children for the benefit of something, whether it's reimbursement because your son or daughter bought you whatever and you need to reimburse them, or for their kids' education, so much better to make the payment directly to, if it's for education, then you write the check to Howard Community College. You know, don't pay the check to your son or daughter and have them write the tuition check. It's better to make it directly payable to the institution for the benefit of that grandchild. Yes.
Given the basic documents are in place and you're outside the Medicare direction,
Mm-hmm.
how about using the basic documents versus a trust?
That's a good question. So when most people ask about using a trust, most people are talking about a revocable living trust, your run-of-the-mill vanilla trust, the Susie Orman trust that everybody has to have, okay? That type of trust does nothing to protect the assets against Medicaid costs, and it does nothing to protect your assets for tax purposes. A revocable living trust, which is what's most popular, is done primarily to avoid probate, so that when you die, you don't own anything in your name. All of your stuff is owned by your trust, and a trust doesn't die, it lives on forever. So that's why people use revocable trusts. But a lot of people falsely believe that their assets are protected because they're in a trust, and that's not the case. In fact, the rules regarding trusts are twice as long as they are regarding other assets. So they try to look through that any way they can, the IRS as well as Medicaid, to tax that money or make it considered available to you. So it might be good for other purposes, not to say that they're entirely bad, but a revocable living trust will not protect against any of the things that we talked about today.
I have a financial power of attorney that's been properly signed and witnessed, but a family member told me that it has to be filed by the court and I have to get a stamp from them in order for the bank to accept it.
No. No. You're not required to file a power of attorney anywhere. In fact, there is nowhere that will accept it, no government body that will accept your power of attorney to be filed. When you go to use it, what I tell my clients when they come back to sign their documents, part of the execution process is to go through, now what? What do you do with all these papers that you have? And I encourage you to take it to the bank yourself. A lot of times the banks will more readily accept a power of attorney when it's presented by the principal and not the person purporting to have power over you. So it's helpful for you to do that housekeeping item ahead of time, but that's not like a formal filing process. It's just so that they can make a copy and their legal department will review it. One liability shifting mechanism that any third party, including banks, love to use ever since this new form was created, there is another statutory form under that law called agent certification. And it says, if you're presenting the power of attorney, you sign this affirmation under oath that, to the best of your knowledge, this document has not been revoked, that the principal is not deceased, and that this document is in effect as of the date that you're present. So that's the way that if somebody comes back and sues the bank, they can say, oh, no, we relied on them, and they made all of these statements under oath. So that's the only other document I can think of related to a power of attorney that would have to be notarized. But other than that, no. Your will can be filed with the Register of Wills for the county in which you reside. There's not a stamp that goes along with it, but they take the original, you keep a copy, and then they send you a receipt, a safekeeping receipt back in the mail. But your power of attorney is strictly private.
I have a question. If you have your will up to date, and if you have your power of attorney will up to date, so you have these three documents,
Mm-hmm.
when do we come to you? I mean, at what point? I mean, you wait until a person gets ill? I mean, right now we're both in good health.
Mm-hmm. So, what's the best way to answer that question? Sometimes people will sit down with an attorney to just review what they have and make sure that it checks all of the boxes that we talked about today so that you're protected. If that's me, or I would presume with most attorneys, then you kind of get on my radar and I would touch base with you periodically and say, hey, have any of these things happened? I don't believe in a fixed period of time, every 3 years you have to pay to redo the whole thing, but I think if somebody passes, if somebody becomes ill, if you hit the lottery, all of these other things that could happen, then we need to revisit the documents. So assuming what you have is good right now, then there might not be anything to do other than just stay in regular contact.
What has your experience been with respect to those who have long-term care insurance and other assets? And what have you found in terms of whether or not individuals ultimately wind up in Medicaid, given those circumstances?
That's a great question. I think long-term care insurance is a good thing. You have to not miss the boat on the sweet spot when to buy long-term care insurance. You know, I could probably get a really cheap policy today, but I pay for 50 years before I needed it. So that's not cost effective. And if you wait too long and you start to have, a diagnosis of X, Y, Z, high blood pressure, whatever, now it's going to be very expensive to get qualified. The unofficial sweet spot that I hear from long-term care insurance underwriters is around 52, maybe mid-50s would be the right time to buy in. Very few companies still sell traditional long-term care insurance policies. They're kind of dying off. My personal opinion, I think there's a little bit of actuarial unsoundness to these plans because more people used to buy in. I think they expected they would ride that wave and have plenty of money, but now all those people are living longer than expected. They're filing claims for longer than expected. They're staying alive longer than expected once the claims begin. So, and fewer people are buying in. So it's a little bit upside down. So now they have, there are many new products that are available now that are called hybrid policies that are, if you don't use the money for long-term care, then there's a death benefit. So those are interesting products that you could talk to your financial advisor or insurance person about. So hybrid long-term care insurance is good. Maryland also has a long-term care insurance partnership program. So if you buy a long-term care insurance policy, and let's say that the maximum benefit under that policy is $250,000, all those numbers that I showed you that you have to spend down to, if you have a policy that's part of this partnership program, you get to keep that much in additional resources. So if you have long-term care insurance, instead of spending down to $2,500, you would have to spend down to $252,500, and then you would be able to access Medicaid benefits at that point in time. The thought is that the long-term care insurance should prevent you from having to apply for Medicaid. Unfortunately, in my experience, that's not the case. So the takeaway from all of that I would say would be long-term care insurance is a great option to help keep you at home and to maybe subsidize the cost of assisted living care. Don't buy long-term care insurance with the thought that it will cover the full cost of care in a nursing home. It's just such a high and expensive level of care that I have maybe once in 12 years seen a policy high enough with a high enough daily benefit to cover the full cost of care. So I have plenty of clients right now receiving long-term care insurance benefits, and we are applying for Medicaid. So, but as I said in the beginning, Medicaid only covers that very high-end level of care. So everything short of that, like in-home care, which is where most of us would want to be, you're on your own for that. Medicaid will not help you pay for that. That's where long-term care insurance can make an enormous difference to your family, to help pay for care to keep you at home so you don't have to go to a nursing home and consider Medicaid. So I hope that answers your question a little bit. Okay. Anyone else? This is heavy stuff. Sometimes it takes a while to sink in or marinate. And so I love to be a resource. I'm happy to answer any questions you have. The timer will not start when you call me. I'm happy to point you in the right direction. And all of these materials that we went over today, in the interest of trying to save some paper, I uploaded them to my website, and I'll also email them to Audrey. And I think the person who's your technically savvy person said he would make them available to you as well. So you can refer back to this and ask questions as you think of them. Yeah.
I just wanted to make a comment about long-term care insurance. When I applied, I was in my early 50s, and one of the requirements of the insurance company was I had to agree to go to an assisted care facility because of the fact that I had such a small support system within the community, and they were concerned that if I were at home and a provider didn't show up, then no one would know. So I just wanted to throw that out.
I think the other reason that they asked you to do that is if you have a small support system in the community, that it would cost the long-term care insurance company a lot more money to pay for the same services at home than it would to pay the room and board at assisted living. But that makes sense. I'm not surprised by that. Yeah, we're bound by the state rules, but it's a state and federal program. Medicare is the entitlement program. Whenever you turn 65, you automatically get enrolled in Medicare and you pay for your Part B, the doctor visit portion. But Part A, hospitalization, is entitlement. You automatically get that. But Medicaid is what they call a means-tested program, so you have to spend down to meet the financial requirements for Medicaid, which is federal and state. So I'm a little bit oversimplifying that because I don't want to give you so much information that you forget everything that I said. There is a program called the Medicaid waiver, okay? The Medicaid waiver program has like 5,000 slots in it. The term waiver means you have to meet all of the same requirements as you do for Medicaid long-term care. You have to need the very highest level of care. You still have spent down your money, everything else, but they will waive the requirement that you be in the nursing home to get those services. So they will pay for those same services at home or in some assisted livings. Only some assisted living facilities participate in the waiver. Now, the reason I keep saying it's not available to you is because the list, those 5,000 slots have been filled since the day that program was created. And there are somewhere near 30,000 people on the waiting list, which they estimate if your name is at the bottom, you'd be waiting for 5 to 7 years before they called you up and said, hey, we have a spot available for you. So the only way to access waiver services is, and I have clients in this process right now, is to voluntarily go through the nursing home cycle. You have to go into the nursing home, become eligible for Medicaid long-term care, where there are no limited number of slots. And then once you're on the state's payroll, then you apply to be discharged back home on the waiver. And if you can demonstrate, hey, Maryland, all this stuff you're paying for here at the nursing home would be way cheaper if you set up a hospital bed in my living room or at this assisted living facility, and it's more complicated than that, but if we can show them that, then they will approve you to be discharged back home on the waiver, and you skip that 5,000 person waiting list because they're paying for you anyway, so it actually saves them money. Now, why they make you go through to make them pay more before you can come back out and pay less? Well, that's the government. I have no idea why. I mean, they're trying to rebalance it, but that's the way it works right now. Mm-hmm. Okay.
Okay, so I'm going to say thank you to Shannon once again.
Thank you.
I'd say once again the star of our series. So, and yes, she's
Yeah.
going to give out.
I'll leave cards on the table out there where you picked up the materials when you came in.
And thank you again. And we'll see you back in June. That's the Register of Wills in June. He'll be speaking.